welcome to this series where we are discussing articles of Indian Constitution. Till now we have discussed Article 1 to Article 14. Today we are going to discuss Article 15. You see, we have discussed already that fundamental rights, this chapter, it belongs to part 3 of Indian Constitution, and part 3 starts from Article 12 and ends at Article 35. One category of fundamental right is right to equality. Right to equality, which starts from Article 14 and ends at Article 18. The first right under right to equality we have discussed already. Today we are going to discuss second right, that is Article number 15. So let's begin. Article 15, it has 6 sub-clauses, right? We will be discussing all 6 one by one. You please remember that 3 of the sub-clauses of Article 15, the initial 3, they were there in the original constitution, and later 3, they were added subsequently. So we'll be discussing under what circumstances those later three subclauses were added as well. So let us begin. We'll be first discussing subclause 1. So Article 15 subclause 1 says, the state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Right? So basically it imposes a limitation on the power of a state not to discriminate against any citizen on the basis of 5 grounds, right? So firstly, the state shall not discriminate. Article 12, we have already seen the definition of state, right? The word used here is discrimination, meaning state shall not treat anybody negatively, right? And the third thing is, they are only on the basis of these 5 grounds state shall not discriminate. If state discriminate among citizens on the basis of any of the other ground, then it will not be considered as violation of Article 15. What are those 5 grounds? It is religion, race, caste, sex, and place of birth. One important point to remember here is that state shall not discriminate against citizen, meaning this right is not available to non-citizens. It is only available to citizens. So non-citizens, they do not enjoy this kind of right. Unlike Article 14, if you remember, there the word used was any person, not any citizen, and hence Article 14 is available even to non-citizens, but Article 15 is available only to citizens. So I hope Article 15 subclause 1 is clear. It imposes a limitation on state not to discriminate against citizens on the basis of 5 parameters, that is religion, race, caste, sex, and place of birth. Moving forward, Article 15 subclause 2. It says, no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, same as what is given in Article 15 subclause 1, or any of them be subject to any disability, liability, restriction, or condition with regard to a. access to shops, public restaurant, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. So you try to understand here, Article 15 subclause 1 puts a limitation on just state. On the other hand, Article 15 subclause 2, it puts limitation on state as well as private individuals, that they cannot discriminate among fellow citizens on the basis of these 5 parameters only, religion, race, caste, sex, and place of birth, when it comes to such usage of such things. For example, access to shops, right? So a shopkeeper, a shop owner cannot deny access to his or her shop saying you belong to so and so caste, saying you belong to so and so religion. Such kind of discrimination cannot be done even by private players. For example, again, public restaurant, nobody can be stopped from entering public restaurant only because of any of these 5 reasons: religion, race, caste, sex, place of birth. Same goes for hotels, places of public entertainment. Even such public places like wells, tanks, bathing ghats, roads, and places of public resort, which are wholly or partly maintained by the state fund, then nobody can be stopped from using such kind of resources. That is what Article 15 subclause 2 says. Basically, please remember the distinction between 15.1 and 15.2 is 15.1 only puts limitation on power of state. 15.2 on the other hand is applicable even on private individuals, right? Moving forward, Article 15 subclause 3. Now see, 15.1 and 15 subclause 2, basically they have asked the state and people of this country not to discriminate against any section of society. But later on, it was also realized during the debates of Constituent Assembly that what if there are certain sections who are, historically who have been discriminated against, and hence they are not at equal level than other community. And hence for their welfare, for the upliftment of that particular community, state might need to make certain special laws. Such special laws shall not be considered as violation of Article 15 subclause 1, right? Keeping this in mind, 15 subclause 3 was added to the constitution, saying that nothing in this article shall prevent the state from making any special provision for women and children. Women and children, they were considered as a group of people who have been historically discriminated, and hence they are at a disadvantageous position than other section of the society, and hence if state treat them differently, if state gives them special treatment, such shall not be considered as violation of Article 15 subclause 1. If you remember from our discussion of Article 14, there we had seen two kind of equality: equality before law and equal protection of laws. This idea, Article 15 subclause 3, emerges from equal protection of laws, that certain positive discrimination can be done for the upliftment of certain section of the society who are at the moment not equal to rest of the society, right? So state can make special laws for women and children, and that shall not be considered as violation of Article 15 subclause 1 or subclause 2. That is what 15(3) says. Moving forward, 15 subclause 4. You see, in the original draft, in the original constitution, we had only 3 subclauses under Article 15. Now, later on, Parliament had realized, same as women and children, there are other sections also in the society who are at a disadvantageous position, and they also need hand holding by the state. They also need a push by the state so that they can they can be brought equal to other sections of the society. Which are those sections? Here in 15 subclause 4, they have mentioned that for this category of people who are socially and educationally backward and citizens belonging to scheduled caste and scheduled tribe, for them also state can make special laws to uplift them. This move of the state, it also should not be considered as violation of 15 subclause 1 or 15 subclause 2. That is what 15(4) says. Nothing in this article or clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of either SCBCs, socially and educationally backward classes, or SCs or STs, right? For these class of people also state can make special laws to advance them, these section of society. So I hope it is clear. This 15 subclause 4, it was added by First Constitutional Amendment Act in the year 1951. It was not there in the original constitution. That please remember. Moving forward, 15 subclause 5. Now 15 subclause 5, it was added by 93rd Constitutional Amendment Act in the year 2005. The need to bring this amendment was that in the year 2005 only, Supreme Court of India had passed a judgment. The case was Inamdar case. In this case, Supreme Court has said that the reservation which state gives, especially to OBCs, the reservation will not be given in private unaided schools or colleges, right? The private schools or colleges which do not take any kind of aid from the state will not be forced to give reservation to people of OBC community, right? This was the judgment in 2005 by Supreme Court of India. To nullify the judgment given by Supreme Court in 2005, the Parliament has passed a amendment to the Constitution, that is 93rd Constitutional Amendment Act of 2005, which added 15 subclause 5 to the Constitution. It basically has permitted the state to give reservation to OBC community even in private unaided colleges and schools. So that is what has been written in Article 15 subclause 5. Right? Only exception here is Article 30 subclause 1. So under Article 30 subclause 1, which is a right to minorities, right? That minorities can establish their own educational institutions, minority educational institutions. In these MEIs, the reservation to OBCs cannot be given, but in all other educational institutions, the reservation can be given by the state to OBCs, no matter whether they take aid from the state or they don't take aid from the state. That is what Article 15 subclause 5 is. Please remember, it was added by 93rd Amendment Act in the year 2005. And the last act or the last subclause under Article 15 is 15 subclause 6. 15 subclause 6, it was added very recently in the year 2019 by 103rd Amendment Act. So till now you see the 15 subclause 4 only allows reservation benefits or let's say upliftment benefits to be given to people of socially and educationally backward class, SCs and STs. 15.3 on the other hand allows state to take such measures for women and children. Now under 15.6, state has given the certain or the same kind of benefit to people belonging to economically weaker section, right? So all those who belong to economically weaker section but are not able to take benefit of reservation or any other upliftment measure under these category, under SCs, STs, women, children or SCBC, all such population who are poor will be getting the benefit of reservation under Article 15 subclause 6. So that is what is given under Article 15 subclause 6, that economically weaker section will also be allowed to give certain positive discrimination against them also. For them also positive discrimination can be done by the state under Article 15 subclause 6. They have further mentioned here that up to 10%, maximum of 10% reservation can be given to EWS community by the state. So that is what Article 15 subclause 6 is, that was added very recently in 2019 by 103rd Constitutional Amendment Act. They have further written in the constitution only that for the purpose of this article and Article 16, economically weaker section shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage, right? So who will be considered as EWS, economically weaker section, that will be determined by the state from time to time on the basis of their family income or some other indicators of economic disadvantage. So right, and hence government has later on notified the criteria to be considered under EWS category as well. But I hope it is clear. Article 15 broadly asks the state and individuals, private individuals, not to discriminate against fellow citizens on the basis of 5 parameters, but there are certain exceptions to it. State can make special laws for women and children. State can make special laws for SCs, STs and socially and economically backward class. State further can make special laws for EWS, economically weaker section. That is what Article 15 crux of the Article 15 is. I hope it is clear to you. If you have any doubt, you can ask in comment section, and thank you so much for watching this video.